Thank you very much, Mans. I think the best time for me, before I read your essays, your articles, generally on the same topic that you anticipate you in this keynote speech, is when on the video, and this is also an announcement for our distinguished guests and delegates, we'll get communication when everything is on the video of the website. And you know, all the 7 past editions and 7 keynote speeches by Mans and by everybody else are on the video. So you can still find Professor Francesco Berlingueri's speeches of the first 3 editions, and all of you who contributed, like Mans and Giorgio, on the website. So I think we should send Marilia a communication that, because many people don't know this. And I'm always a little bit, I have to look after also the organization, and Brian had just to go for this other commitment, and I asked my daughter to, so I missed some bits of Giorgio's and Mans, but as soon as they are on the video, I will watch them, and but I thank you in advance, because I listen enough to thank Mans and Giorgio for their very important contribution to our conference. And now is the time of starting the roundtable discussion. And so I would like to ask the panelists, among whom there is also myself, so I will try to be a disciplined panelist, and thank Giorgio Berlingueri and Mans Jacobson, and say goodbye to them. And so I hand over to Clive Aston, who has been president, is a very famous and distinguished arbitrator of the London Maritime Arbitrator Association. Up to a few months ago, he covered the prestigious and very important role of president of the association. And I think during his presidency, the LMAA has been very actively represented all over the world, also in the Far East scenario and a bit everywhere. And I thank him also for mentioning at the last dinner of the LMAA about the shipping of this conference, even though, as rightly Mann said, it's not very legal. I mean, we try to put together many things. I think Clive will have the role to keep us short and have possibly a real round table, regaining some time for the next and last session. So short answers, and this is almost impossible having me among the panelists. And Clive will also briefly introduce the other panelists of this session. Thank you.
Thank you, Francesco. I think all of the speakers will have mentioned when they've opened what fantastic surroundings we're in today. And Francesco has certainly given himself a challenge for next year. And I think we should perhaps make some suggestions for him as to where we can go from these surroundings. Whether we perhaps look to hire the island of Capri for a few days. It's going to be very difficult to do better than this, Francesco, and congratulations.
If I may, Clive, perhaps I was thinking next year to stay here. There is a beautiful, unfortunately very expensive, because here everything is, but this is terrace over the sea, like in the Babylonia gardens called Giardino Pensile, the same word we use for the Babylonian, how do you say, gardens.
Okay.
and you can see the harbor, and we can have the party perhaps a little bit earlier in the year. And I think if we work together, we could have a full theater, fuller than yesterday. That was obviously almost quite full. And this is 400 seats. And I hope to have the 400 seats, and so we can have a beautiful time, because I think the performance from a theater is great, no? And
okay, well, the challenge is there.
we can make a vote.
Right. Now,
by email.
On the question of timekeeping, the best chat shows on television last about 1 hour, including the adverts. If you take away the adverts, they last about 45 minutes. So I think we'll try and keep this session strictly without the adverts and limit ourselves to 45 minutes so that we can catch up on the schedule. Now, I'm sure everybody here understands that when you enter into a contract, you do so with positive hopes and expectations. But it's an unfortunate fact that things go wrong and disputes arise under a contract. It may be simply that a party doesn't want to pay. It may be that there is some event that happens that neither party thought about. It may be that there's a genuine dispute as to what the law is, or the law might change. And so these disputes arise. So what do we do in shipping? Well, mostly we go to arbitration to have those disputes resolved. Now, in London, we have a huge number of arbitrations. In 2016, there were 3,000 appointments, which equates to about 2,000 new arbitration cases. Now, that suggests that there is still in the shipping community a pretty strong hunger and appetite for arbitration. Now, we in the LMAA issued new terms this year, which followed consultation with the market, with a view to trying to cut out as many as possible of what people say the abuses of arbitration are, to try and cut down on the time and the cost of arbitration. But I wonder how successful we are, and it's always useful to get feedback from people in different sectors of the market as to what they really think about what we as arbitrators are doing and what their options are when a dispute arises. Now, I'm lucky to have with me a panel today who represent a cross-section of the market in arbitration. I have Luigi Morselli, who is General Counsel for Wärtsilä, covering the areas of Southern Europe and Africa, who offers us the perspective of a user of arbitration and other legal services. I have Francesco Lauro from Studio Lauro, who is an Italian lawyer, but regularly handling disputes not only here in Italy, but in London on behalf of clients here in Italy. I have David Pitlarge, a solicitor from Dickinson in London, who is at the forefront in handling arbitration cases on behalf of clients internationally. I have Roderick Cordara QC from Essex Court Chambers in London, who is presenting the cases in arbitration and advising clients internationally on their prospects in arbitration matters. And I have Jonathan Lux, a world-leading mediator and also arbitrator, who is dealing with disputes when they arise, particularly mediating disputes between parties as an alternative to arbitration. So we cover, I think, the whole range of people who are involved, and perhaps occasionally I can add a perspective from an arbitrator's point of view. So I've set myself a couple of broad questions to put to our panel today, and then let's see where that takes us, because this is not rehearsed. It will be totally spontaneous, and I've said to everybody, there is no script, no speeches, just plain answers to keep matters moving. But the first general question that I've put down here that I'd like to ask the parties is, does the dispute resolution system really serve the needs of its users? And do lawyers add value to the process? So let me start with that first question. Does the dispute resolution system suit people who are in need of it? And I think the obvious place to start with that question is Luigi Morselli.
Thanks, Clive. Unfortunately, I'm so long in the business that I can talk since in '94, something like that. But if I go back 5 years, I think that Wärtsilä was involved in a material number of major disputes, both before court or arbitration. If I go now, Wärtsilä dispute environment, I don't see any new major court case in the last 3-4 years. Some dispute, a lot of claims, also big claims, but zero dispute, major disputes. What does it mean, major disputes? Higher than a couple of million, of course, for us. So why? Of course, there is a commercial reason for that. We are seeking to have a strong partnership with our customer, and so we are trying to avoid at any cost to dispute and to claim and to fight with our customer. But the second point is that in order to get a settlement, we put on it, together with the customer, the enormous cost of arbitration, or the arbitration as a procedure, plus the legal expenses. So, in order to save the commercial relationship, in order to get also a better economic result at the end of the story, we are trying to settle at any cost all the possible disputes. So this is something that maybe arbitrators, legal staff, law firms have to consider. That's at least the starting point for me.
Right. Now, I can understand that from your point of view, a commercial relationship is always very important.
Yeah.
And is there a feeling that if you arbitrate, that you're putting in danger that commercial relationship?
Of course. To have a friendly solution of any claim and any disputes is it's our main goal. It is my main goal as a legal employee of my corporation, because as said, we are willing to establish a real partnership with our customer, but the same I have to say that also the customer are willing to seek towards us a good partnership. So even though we are claiming and we are fighting in a very heavily way, in some circumstances, at the end of the story, during the last 3, 4, 5 years, we have been able to find fantastic solution, avoiding any, sorry for you, legal cost, which is unbelievably high. I was talking, just to make a reference, some years ago I was involved in a small arbitration in London as a defendant, not myself, of course, the Wärtsilä. And at the end of the story, we were a winning award. The award, we were awarded around 1,800, 600 K pounds, and the procedure cost was addressed to the losing party, but the legal fee, the reciprocal legal fee, was held by each party. I paid 80,000 K pounds to my law firm. That means that it's absurd for me as a company, and I could have been investing this amount of money in order to save time and to get a good settlement involved, at least investing half of this amount. That's my very easy thought.
But if in your case the legal fees had been much lower, would that encourage you to fight more cases, or is the commercial side?
This was a particular case. It was not a client. It was just we were just talking about IPR infringement. So in this case, of course, it will be much. At the end of the story, I will be much more happy. But but of course, in this case, the dispute was not avoidable. But if you are talking about, for example, without mentioning without doing any names, or without referring to any names, we had in the last year a very important claim with one important player in the maritime business, but we have been able to settle in a fantastic way, increasing our commercial relationship, also putting in the scope, not in the scope, but also putting in the account a certain kind of less provision for legal fees. So that says something. It should be say something at least. Of course, the cost is a key aspect. And then there is also the uncertainty of the judgment. If I can say something, talking about civil law system countries, the decision is less predictable than the common law countries. So in this respect, I prefer the arbitration because it's much more predictable for me. So, but anyway, at the end of the story, it's a fight, and we will try to avoid any fights. Also consider the cost implication.
But David, are you seeing a similar reaction from many clients where they're coming to you and maybe asking for advice, but then deciding that arbitration is just not a viable option anymore? I mean, how does one explain the huge number of cases that still fight?
I think there is an unevenness. The answer to your question, which is the system serving the users, I think could be yes, but. And I say unevenness, and I can think of, and I think it's quite helpful, as Luigi says, to talk about the numbers, because I think they give some context. And two anecdotal observations, I think of an MOA dispute I had about 10 years ago, and there was about the seller had obviously cheated the buyer, and there was justice to be had. And it involved a whole range of steel work, wasting steel, and the usual sort of shopping list of defects. There was about 1.2 million at stake. That's a substantial sum to me. I don't think there was indulgence or excessive aggression on the parties, but after a year and a half, when we came to start looking at the hearing and budgeting, it was going to be about £600,000 each side to cost. That's 1.2 million sterling plus a 3-person tribunal to fight $1.2 million. And I remember the broker was very angry. He said, "Are you telling me in London it's not worth fighting over $1 million?" And I said, "On these figures, I'm not saying it's not worth fighting, but you should settle." So that's a problem for the system. On the other hand, if you look at quite a lot of demurrage type cases, charter party cases, cargo claims don't really come through the system, I think, for the reasons you're hinting at. You might see 50, 70, 100, 150,000, even 200,000 settled for maybe £25,000 if you go through the system. Now, if you were to go into the ordinary civil commercial world and have, say, a partnership dispute or a shareholders dispute for similar values, you would actually be paying a lot more than that sort of notional 25,000 figure. So in part it works, but as I say, there's an unevenness. And I think another perhaps good comparison is in the trade sector with GAFTA and such like, where you have quite substantial amounts. And there, rather like Luigi says, you have regular combatants. The trading houses always fighting against each other, and the costs are relatively low there for big sums. So, I think, as I say, a qualified yes, and you could optimize the position perhaps by finding out why those disputes which work commercially or are cost effective to fight, find out just why that is so, and maybe adopt the procedures to ensure that happens more often.
Why do you think dispute resolution, and let's not limit ourselves to arbitration, but why is dispute resolution so expensive? Why has it become so expensive? Because the original idea of dispute resolution, certainly arbitration, was that was to avoid cost, to go to a trusted middle party like an arbitrator or mediator, and to get him or her to express their view, and that was it. But why now is dispute resolution so expensive?
I think I missed out. I started my career just as that generation was changing, and all I had to go on was the anecdotes of gin and tonics at Cedric Barclay's flat, actually, and a simple exchange of papers no bigger than this. I suspect the answer is partly because, in an almost paradoxical way, progress. It's much more sophisticated. You've had law firms who've grown up. A shipping firm, say in the 80s, would have been 20 partners. now might have 150 partners, a pyramid of associates beyond that. How many comes the question for Roderick? A handful of QCs at each chambers, now many. So everything just gets more sophisticated. The subdivision of expertise, because let's not forget that although the lawyers often get it in the neck, it's sometimes worth thinking about where the money really goes. It's the solicitors take some, of course, we'll take the flak for that, then counsel, then arbitrators. A lot of money is spent on expertise, and if you've been certainly casualty work, by the 90s you're seeing things like finite element analysis and such like. And that's, I think, got a little bit out of control in some of the bigger cases. But it's sophistication, and I suspect a reluctance to be someone who wants to draw some sort of boundary of arbitrariness to stop that.
I mean, we talk a lot to users of arbitration, and increasingly we're seeing people say, well, we'd love to get back to the days when it was very simple and straightforward, and let's go back to those days as much as we can, although often when it comes to an actual dispute that involves that party, their attitude is totally different. But are we talking about a way of resolving disputes that's going to almost make, put pressure on the role of the barrister? I mean, are we squeezing barristers out of dispute resolution, Roderick?
Well, I think that the role of the advocate performing in the arbitration room has definitely altered over the years. And it has altered in the sense that speeches are much shorter, much more is expected of the arbitrators in terms of behind-the-scenes work and reading. And I think there's been a lot of pressure from the wider arbitral community, by which I mean arbitration which is not to do with maritime disputes, where the model has been slightly different. But I'm very struck by what Luigi said. Clearly, as one would expect from Wärtsilä, he represents a very sophisticated type of client. And it's always a joy when one has a client of that kind, because you know that the client sees the arbitration or the court case for what it really is. Number one, an investment decision, which is progressive, not committed, as we all know. You start, and you may take it through to the end, or you may not. And secondly, as a means, hopefully, of engendering a settlement. Now, in the case of Wärtsilä, clearly they are looking at ongoing client relations. They want the next order. In other commercial relations, when the two parties may never see each other again, one doesn't have that dynamic. But to come back to your point, and to pick up on something that David said, there are huge cultural forces in play. We'll come later to why there's so much work in London still. But being somewhat older than David, I do remember, and perhaps you and I remember, the world of maritime arbitration of, say, 30 or 40 years ago. And it's good to recount that world, because it could, I think, it could come back with goodwill and good sense. In those days, cases weren't necessarily any simpler. The world was simpler, there were no computers, but ships still bumped into each other. That's something perhaps which is less frequently debated now in the world of GPS. But things went wrong. And as far as human error is concerned, nothing has changed. What would, in those days, happen is that there were features of the arbitral process which were designed to keep everybody friendly. We would all have lunch together during the arbitration. The arbitrators, the parties' lawyers, the witnesses. I would sometimes spend the morning cross-examining a master, suggesting to him that when he hit the iceberg, he was drunk and in his cabin. We would not quite finish. I would sit next to the same man at lunch. I would ask him if he wanted red wine or white wine. We would drink, we would talk about holiday plans, and then in the afternoon we would start again. And it was a world, therefore, in which, as indeed Clive has said, arbitration was a feature of a relationship. It wasn't a disaster. It had positive overtones. And I think that we've lost that partly through the Americanization of litigation perhaps in Europe, certainly in the UK. Everything is documented. Every argument has to be written down several times and so on. And one of the great strengths, to which I suspect we'll return, of the LMAA is that it is, of all the different arbitral solutions, it's the one which still keeps the lightest touch and stays in the best degree of contact with that past, which perhaps I'm viewing somewhat romantically. But I certainly think that after a heavy lunch and a glass of wine, the afternoon proceedings did go much more smoothly than they do now in the days of acqua gassata and a small sandwich.
Okay. Luigi, when you are handling cases, do you keep a very close eye and control on what the lawyer is doing?
Of course, yes. Yes, yes, of course. I have to say that, okay, I'm working in a certain part of the world mostly, and there are completely different approaches. If I talk with a law firm, UK law firm, maybe assisting me in Paris or whatever, of course we are talking about hourly fees, possibility to have a success fee or not, possibility to have a lump sum or not, something like that. In other country, there are fixed fee tariffs or whatever, so it's completely different picture if you are looking at my area. Of course, depends. In most of the case, of course, I'm going to work on a continuous basis on certain law firms. So in principle, I know what what it will be out at the end of the story as a fees. But anyway, I have a close eye on the rolling of the cost. Yes.
Because one of the thoughts that we often have.
But if I comment one thing, I was very appreciating what Roderick says. That sometimes started issues could be a tactical move or a strategy move. That could be also a good example. You can use to get at the end of the story good settlement, or starting a mediation, the same, but could be used as a tactical or strategic move. I share your opinion completely.
I mean, the danger of starting an arbitration for strategic reasons is that it's not always easy to get out of something that you start.
Yeah, exactly.
So it's
in
not
fact,
an easy.
Sometimes could be tactics, sometimes could be strategic. You have to make as always in the life, you have to make the right decision if you will be successful. Maybe it could be a wrong decision, so you are not successful at the end of the story.
I mean, I raised the point about your role in handling of cases because we often get the sense that a party will give a case to their lawyer, and perhaps where it's not the biggest claim in the world, they may then leave it in the hands of the lawyer. And then
it will be the biggest fees, yes.
Yeah,
yes.
They have no idea what's going on in the case, and then they complain about the fees at the end. So there's an important role to be played, I think, there.
Yeah. I think that I've been benchmarking with my colleagues in other company, and in big company, all these costs as monitored properly, almost properly, let's put it like this, because it's extremely important. And the awareness about that is, as said, we put in the cost of the settlement, the negotiation, also a possible legal fees, just to let you know how deeply we are going in evaluating this kind of stuff.
So step-by-step control and budgeting is always very important.
Yeah.
But Jonathan, are you seeing more people go to mediation? I mean, mediation's been around now for about 20 years. There are no published numbers, so we don't know how often people go to mediation in shipping. But do you feel the numbers are increasing as a result of, people looking for an alternative to what we've been discussing?
There is some published data. There's an organization with its head office in the UK called CEDR, the Center for Effective Dispute Resolution, and they published quite a useful biennial audit, which I think concludes that about 10,000 cases a year across the commercial spectrum are being mediated, which is quite small, but it depends upon returns from people like me. So if anything, the number will be understated. Focusing directly on your question, Clive, I think mediation has not been as quick to take off in the maritime field as in some other fields. Construction, it's very popular now. Lots of construction disputes are going to mediation. And because subject matter knowledge is not an essential for the mediator, I in fact find myself mediating quite a wide spectrum of disputes, not only maritime disputes. So I think there are maritime disputes going to mediation, but there's scope for a lot more. If I could just briefly address the question of what the users may want, I see it as a bit like a restaurant, but then I wouldn't I, with my largish bulk? I think the user would be disappointed to go into a restaurant and find only one dish, only a meat dish, for example. And so I think the way things are developing, I mean, David mentioned increased sophistication. I see it in terms of actually increased choice. You can go to court, and that's perhaps the meat dish. You can go to arbitration, and in fact, London Maritime Arbitration, I think, is extremely flexible. With two willing parties, you can adapt the procedure so that it does work economically, for example, by agreeing to dispense with an oral hearing, by agreeing to go on documents and submissions alone. You can have a very cost-effective arbitration. And then, of course, there's the possibility of mediation. And indeed, there are hybrid processes like med-arb, med, where you may start in mediation, have an arbitration phase, it could even go back. So you have various hybrids as well.
What we're often told is that the shipping industry is quite unique. I mean, Roderick, you don't just deal with shipping disputes. Sometimes people from other fields say, is that all that you charge? Now, in other areas, John mentioned construction, finance side, the monies that we're talking about as payable to the lawyers are much, much more. And it's a feature of shipping, isn't it, that people fight for much smaller sums of money. And the problem has been that, especially as the market has come down, the level of the claims has become smaller. And so it's far easier for costs to appear disproportionate to the amount of the dispute.
Yes, and I think that one of the strengths of, say, the LMAA system is that the people who participate in it tend to have the mindset which you've just described. They know that the market does not expect high charges, and I'm thinking in particular of the arbitrators themselves. They also know that the market wants a quick solution. One of the ironies of the world that we're talking about, not just arbitration, and building upon Jonathan's reference to restaurants, subject dear to both our hearts. When you choose a restaurant, particularly if you want a memorable experience, you will choose one which perhaps at which you will have quite a long, elegant, but ultimately expensive meal. When you're in our world, the maritime world, and you're picking your dispute resolution, you want the opposite. You want certainly the speed and possibly the price of McDonald's, although, of course, you want the quality. And that is something certainly which the many years of experience in London, and no doubt other places, can deliver. I recently had a 7-day hearing of a very technical nature to do with fuel consumption in London, LMAA. We had 7 working days, QCs on both sides, clients from East Asia, and the award came through about 17 days after the close of the hearing. You will not get that in any other field. And that impacts on cost, because I happen to know that one of the arbitrators was busy for certainly one of the weeks, and he was the presiding arbitrator. So the costs are kept down where arbitrators are in good touch with the market they're serving, to where there is a culture of getting to the point rapidly. And for example, with LMAA, procedural steps tend to be only those things which are essential. One is not encouraged to produce paper. And from a lawyer's point of view, certainly from my point of view, that is a more enjoyable experience, because we obviously do what we do because we love the battle, and it's good to get to the point, and arbitrators wish to do that. I'm not saying that that is the uniform experience. Much turns on the arbitrator's identity. And the other difference between the world of arbitration and the world of restaurants is that you pick your restaurant, LMAA, SIAC, whatever, but then you can pick your own chef. And one has to choose wisely. One has to choose someone who is busy, but not too busy. And of course, since the market everybody is known, there are some arbitrators, the majority, who are very fast, but 1 or 2 who Francesco and I know, who, while offering great quality, do take their time. So a sophisticated client like Luigi will be able to have a conversation with his legal advisors about these matters, and Francesco equally so. The less sophisticated client will heavily depend on us to guide them, and it's our duty to guide them well to a solution which will deliver, obviously, the most cost-effective and the swiftest outcome.
Well, that leads me on to a question I had for Francesco, which is really, does the lawyer add value? Where do you think, where do you see the value of what you're doing for your clients, and how can you add value to their, how can you fulfill their dreams, if you like, with their cases?
Well, that's a dangerous question. Generally, the majority of my clients are males, and I don't want to think about the female clients because it would be even a more dangerous area. So I think the last thing I would like to do in my life is fulfill the dreams of my male clients. And having said this, so let's pass from this hell scenario to a scenario that Roderick suggested. Yeah, it's a restaurant, and then you have to choose the chef. But I think the word of dispute resolution and dispute handling, so dispute avoidance, if we consider mediation. For all my clients, every time I try to go to Jonathan or one of his colleagues, they say, well, Francesco, you can sort out a settlement yourself. I say, well, not a lot of money, perhaps we could save money. Or the alternative to mediation is that if it's introduced, we have a case here, very large CTL and loss of cargo and salvage case. And there's other lawyers, they wanted to have a mediation, but without a proper preparation. This cannot be done, because why meeting with a mediator if you don't give enough time to present the case? It's useless. It's like going to a casino with the money, and it's very dangerous. I think you can lose time and money, and even perhaps jeopardize decent, reasonable settlement. But going back to your question and to my sort of tour operator example opposite to just go, yes, I think it's a package, and the arbitration or the mediation can be part of the package. And you say, we're a lawyer that I think you mean as me, as anybody of us, or including my colleagues, some are on the stage, some may be on the other side. What the lawyer of the client could do, then, okay, you may have a team and she's led arbitration, in some cases with a barrister, with more than one firm. And I think Roderick and I are involved in an arbitration I would like to mention without saying the name of the part, in which Greek lawyers and Italian expert witnesses, and because it's a multi-law contract, let's call it so. I got a very new judgment for you on this. And so the barrister is involved, and the arbitrators are also retired judge, and so all these people is involved. So we're also to address the problem raised by my colleague Morselli of Wärtsilä. I think it is very important, if you want to represent a client, to know your client, because you have to know what your clients want. This is important from the time you negotiate and draft a contract. And it can be also important in handling a situation that may lead to a dispute. I will make just two examples, practical examples, very recent. At the beginning of this year, we had a client with a large shipbuilding contract of $500 million. And this vessel were not perfect. So unfortunately, this vessel are very good, but they created a loss of problems, repairs, and but also not a good service to this line. Therefore, my client had a huge loss of profit claim. And one of the problems is that it was very difficult to quantify, because when you lose a client, did you lose it forever? You just have to count the vessel, the time the vessel has been stopped for repair, already, something like this. But I think all of you know that notwithstanding the fact that the shipbuilding contract generally have a guarantee which covers only the repair cost of a vessel, this is not true, because generally these cases are awarded not perfectly. And unfortunately for the shipyard, I was involved also in the negotiation process. So I made this little imperfection of the clause itself were announced by a little bit of negotiation with this Chinese very good shipyard, but probably the use of English language was sometimes even worse than mine. So in the end, this clause did not, I think, excluded also indirect damage, and we know that loss of profit could be a direct damage. The war, theoretically, as the law stood up to the end of 2016, we could have had a huge claim against the yard. But my friend Simon Curtis, who attended many editions, and he's the main writer on shipbuilding and wrote the main book for Lloyd's Press on shipbuilding contract. On the 2nd of January, he sent me, I said, Happy New Year, I merged my firm with another firm. And perhaps I think this is something he sent to his friends and colleagues, said, you may be interested of this judgment, Star Polaris. And we were in the middle of that, and the Star Polaris, I think, was issued at the end of November or in December, was not yet published. So I got this from Simon, because Simon is the authority on shipbuilding. And I gave advice to my client, said, okay, we can have a good case. Let's negotiate very toughly, and if they don't agree, we don't settle at our condition. We go to the arbitration. The only way I was a little bit reluctant that my client was not able to quantify this claim. We didn't know if it was 20 or 50 or whatsoever, or 100. So the Star Polaris judgment, now I will not go into details, there are a lot of good lawyers around, this is not the object of this conversation, substantially changed the law in my opinion, not necessarily in a good way, and the actual prospect of a success for a loss of profit claim after the judgment diminished a lot, I think. And so I said to my client, sorry, I give you advice, but the law has changed. And we have to settle. And quickly, we got $15 million that I think they were lost without this very photo.
So the important thing that you're emphasizing
yes,
here is the
contact with the client.
And you know, many times in London, we see that there perhaps a straightforward claim that the owner or the charterer will go to the club will then go around, see who's going to provide the cheapest deal. The lawyer won't know the client, and so you're going to get a very pro forma service. The value that or the qualities that you are saying are good is continuity, so that you know your client, you know what their objectives are, you can be more creative with them, and you have that closer contact. Yes. So that when things come to you, you can look beyond the instruction. Exactly,
and I was involved in the day-by-day negotiation. I was writing their email without saying that word. So I exactly knew, and when we were able to change and arrive, and I think that's why we have to work as a team. I'm sure that if Roderick presents the case before the arbitrators, he does it in an exceptional way. I've seen as many of others of you. But obviously Roderick as a barrister particularly, but also perhaps the lawyer appointed, the solicitor by the club in London, who hasn't got a line. If I work with David, I think it's very important that we exchange all the information, because I know exactly what the client, if it's my client, is doing, and he is more in contact with the rest, the end of the chain, okay, and we must exactly know what. I'll take another example. Obviously, I must delete from my communication.
Francesco, let me stop you there, because I think we have to keep to our promise on the timing.
Okay.
And I think we need to move on,
yes,
if we can, to the second question that I had. And I think what I'll do is I'll put the question to each of you to come up perhaps with one thing that you think stands out in your mind. And that question is, what changes can we foresee in the way in which disputes will be resolved in the future, or maybe even the type of disputes that we'll be dealing with in the future? And I'd ask that each of you provide one point that sticks out in your mind as possibly a change that we're going to see coming in the future. And I'd start with you, Luigi. I mean, what do you see as changing?
I think that I've already shown what does it mean for me changes. I start to stop to dispute. I try to stop to dispute at all. That's the future for me in the big corporation. On the other side, if I see that in general, I think that all the alternative dispute resolution methods are more than welcome, starting with mediation or any kind of other stuff. And for me, preferably is an arbitration. I said in general, the arbitrator decision is more predictable. What is the key for arbitration in my mind is that the reputation of the arbitration chamber or the arbitration organization. Honesty, for example, is primarily important for me, because it's not given for granted. It should be, but it's not. And said that, I think that big company will try to avoid any dispute. because, as I said, the uncertainty and the cost and the time is important. Of course, there are good systems to try to get, when it's coming the dispute, good resolution. I will push for alternative dispute resolution methods and arbitration.
I mean, you had mentioned to me earlier, we had a very interesting conversation, that you thought that we might see disputes in the future arising about cybersecurity.
Yes. Yes. We are, as a group, okay, I take the opportunity 1 second to challenge one assumption heard yesterday from a panelist, said that he was saying that there is no technical way in order to prevent pollution. I totally disagree on that, of course, because we have just sold the first hybrid system, for example. Means that we are able to make a sail, a boat sailing or moving without any emission. When it is operating by battery, of course. And with the solution that we have in our portfolio, dual fuel engines means diesel and gas plus battery. We are also producing something. So I'm coming very shortly. What means that all these systems are based on digital means, automation means, a lot of digitalized equipment, which also be protected by rules and clause of cybersecurity, because they have an external interface which might affect the integrity of the system. So in our contract, that is rather new for our business, we are introducing cybersecurity clauses, cybersecurity protections. And you see, because I don't know if you have read on the newspaper some months ago, a major player in the market has been under a cyber attack with a lot of substantial disadvantage and cost and damages. So in the year to come, in this respect, we will see a very improve of importance of this kind of clause, and on the consequence, the importance of the knowledge from the legal perspective and also for the decision and the dispute resolution perspective.
I think the dispute you're mentioning was one that involved Maersk, and I was in Denmark a couple of weeks ago at a conference, and certainly cybersecurity is the hot issue of the day at the moment, and I wondered what the issue was, because obviously we all know that your systems can be hacked into, but we're looking essentially at clauses dealing with the apportionment of risk for cybersecurity, where, for example, with remote control of reefer temperatures now, if that is hacked into, where is liability going to arise? So the scope for this potentially is enormous, isn't it?
Exactly, absolutely. Because the interface between the system of the client and the supplier is extremely important. And in some way, you have to address the reciprocal responsibility and, of course, the reciprocal risk. And it should be landed in a dispute, of course, if some like this happen again.
David, what do you see as likely to change?
I think we're going to see a very radical change in the whole way that costs, funding and recovery are dealt with. And I think that process has started, and I think it's going to accelerate. I remember probably 12, 13 years ago at my last firm, we had our annual conference, and we had the then economics editor of The Independent as our guest speaker. And as he was starting to talk about the movement of capital and the rise of Asia, one of the more senior partners popped his hand up and said, all we really want to know is how much longer we can charge a premium on inefficiency. The whole business of the hourly rate, the elasticity of billing, I think, is going to change. You can see it in the way the court is now asking for statements of estimation, cost estimation. It's quite a sophisticated process, and if you depart from that, you're not going to recover. So that militates on this sort of aggregation of hours. I think we haven't really mentioned the clubs, and they are, certainly in the pure shipping sector, very big funders, and they are not unreasonably, pushing certainly the solicitors' firms very hard to get away from a basic product of hours times rate. It's not enough just to lower your rate, you have to come up with other things. You can tell me how you look at these things in the LMAA, but I remember your colleague Michael Baker-Harbour for some years, certainly some years ago, was an advocate of capped fees, so that might be an answer. And the sums, going back to what we were saying earlier on, are getting much higher. So you're also seeing third-party litigation funding for the bigger cases coming in as a feature. You've seen 2 or 3 landmark cases. There was the Excalibur fiasco in which Clifford Chance did themselves no great service. But there the costs were about £17.5 million. And that was the inadequate security. And the funder was told to pay the indemnity costs. He couldn't dissociate himself. And similarly, in the recent Esser and Norskott case, you had an unmeritorious repudiation. The claimant had no choice but to go to a funder. Typical of these agreements is a 300% markup on your fees, and that 200% uplift, I suppose, was recoverable as reasonable costs under Section 59 of the Arbitration Act, upheld by the Commercial Court. So I do think to encapsulate that, the idea of just charging by an hourly rate in this aggregation process is now going to change and change very quickly.
I think certainly from my perspective, the feeling I have is that we're moving towards the capping of costs in cases, if you like, fixed price arbitrations pretty quickly. And I think going back to what we said earlier about lawyers' costs, if you say to a party that if you win this case, the most you can recover is £50,000, then I think the effect of that will not be to prejudice their case. It will just mean that they will rationalize the matters they deal with, the way in which they deal with the case, and prune it down to what is necessary, rather than trying to bring everything in and hope that some of it is relevant as they do now. But Roderick, what do you see as the issue of change?
The big change which is going on globally, both in arbitration maritime, arbitration beyond maritime, and court-led dispute resolution, is an explosion of choice. Never have so many people in so many countries, in so many contexts, been competing for your business in terms of ship owners, ship operators, people with disputes. What I have in mind is that there is now obviously global competition between arbitration centers. Sometimes it makes a difference whether you're arbitrating in Hong Kong or London. Often it doesn't particularly, but the pool of arbitrators may differ, the rules may differ, and in terms of competition now between courts, we've spoken a lot about arbitration, but you should know that there is now fierce competition between the courts of various countries. You've got Commercial Court in London, you have the Singaporeans, who are very vigorously offering a challenge, and it's an entirely good thing, to the Commercial Court in London in the shape of the Singapore International Commercial Court. And then you've got the DIFC Court in Dubai. So there has never been a greater opportunity to choose. Of course, the arbitration or dispute resolution clause is the Cinderella clause. No one thinks about it, especially if it's a tailor-made contract, because it's always dealt with at 3 a.m. in the morning, or not written in at all to the bill of lading, because they only photocopied one side. But it is actually a choice which is worth thinking about, but in respect of which guidance, perhaps even for the most sophisticated client, guidance is needed. But there has never been a greater opportunity to find the solution that suits you.
I obviously have a vested interest in London. I've just come back from Dubai, where, as you say, there is now a push for arbitration. But I think, I said no advertisements, but I think one has to acknowledge that in Singapore, in Dubai, on the whole, they don't have a local panel of expert arbitrators who are experienced in the industry. Mostly they import the panel of arbitrators from overseas, so many London arbitrators are on these panels, or they have local practicing lawyers as arbitrator. And I think that the industry has always sort of shown that it prefers to have commercial people deal with its disputes rather than perhaps people from a purely legal background.
May I quickly agree with that? One of the great strengths of the London Maritime Arbitrators Association, the LMAA, is that one may well have a panel. I sat on a panel last year, shipbuilding dispute. I was the lawyer. I wasn't in the chair. In the chair was a chief engineer of many years' experience, and on the right hand, on his right hand, was a commercial man. And we were able to offer, I think, something which doesn't really get anywhere else. I dealt with the legal issues. The chief engineer dealt with the issue concerning the exhaust gas boiler, if I recall it correctly. And then our colleague, who is a commercial man, put it all together and did the spreadsheets for the figures. And I was really proud of the sort of LMA offering. It doesn't happen every day, but it is something which you're not going to find anywhere other than really the LMA. Right. That's the advert. Is that all right?
Perfect.
Yes.
Perfect. Jonathan, what do you see? I mean, probably more from an ADR mediation perspective, what do you see as changing or in need of change?
Okay, well, whilst deferring to my learned friend, I think we are seeing actually now increasingly sophisticated dispute resolution clauses, which often will stipulate in the first paragraph friendly negotiations, then probably in the second paragraph mediation, and then arbitration or court. And we have we have authorities in England, court decisions saying that the mediation provision is enforceable. So if parties have agreed to that, they can be compelled to mediate. In fact, there's even a recent decision saying that a friendly negotiation or discussions clause is enforceable. So I think we are seeing those clauses, and increasingly BIMCO, for example, provide in their latest run of contracts expressly for mediation. Then if I could pursue, excuse me, briefly the restaurant analogy without, I hope, flogging a dead horse. You not only, with mediation, get to choose the dish and choose the chef, but you can actually cook the dish yourself. So one of the vaunted advantages, and I think it's a significant one, of mediation is that it's the parties' own settlement. Now, of course, commercial people invest a lot of time in building up their relationships, and those relationships can be very quickly burnt on the altar of dispute. So that's a significant advantage. You're concluding a settlement, it's the party's own settlement, and very often you're thereby preserving the relationship. Also, I think another significant point is that you have scope for innovative solutions that no judge or arbitrator could order. And if I could just give one very brief example, it involved cancellation of a charter in a falling freight market. The charterers were an oil major. The owners had a fleet of well-run ships. So the dispute over the cancellation and substitute freight was no more than about $1 million. At the mediation, that dispute was actually parked, and the end result of the mediation was a new contract between the parties, whereby the oil major charterer gave the ship owners first refusal, specified cargo, specified voyages for quite a long period of time, which was actually worth much more to the ship owner than winning his original claim, which therefore never got resolved. It was simply left. So choice and mediation featuring and mediation playing an increasing part, I think, in the resolution of maritime disputes.
Last word to Francesco. Brief word.
Some thoughts. I think, first of all, there is Mr. Morselli. We have been discussing the cause of London arbitration, I think 2 years ago, and I was trying to sell him the London arbitration, but he has been almost able to convince me that I was wrong, and then sometimes the cost of the arbitration. I think we should change three things. We should change not only for arbitration, a little bit the rules, how the dispute resolution industry and the legal assistant industry and services work. I think the system that generally is charged by hours, like beautiful ladies sometimes do, or men, I think makes us, is not always very effective, because obviously, let's not think of ourselves, but there is a lot of young or old people in the various firms, and they have to put hours. This is not good. It's also not good, I think, that to have always a lump sum system, because you know that the industry, our clients are very greedy, and they will always go for the best deal, but sometimes the best deal is not the best assistance. So I think we should find new ways that cases could be charged by steps, by time involved, but it should not be the only thing. The good thing, you know, for the lawyers and would be that, you know, if there is a good result, perhaps a little bit of this good result could go also in our pocket if we are more flexible. As to the arbitration conduction, I heard a lot of important things. I think if we want to render the arbitration international, we have to decide if we want to have really unappealable awards. In the end, what makes the real difference is the jurisdiction of any appeal, because there are 3 English people, 2 Italian, and what are we talking about? Arbitration which is appealed before an English court. Obviously, English law and English court could be quite expensive, but it's well known. English is a well-known language. It's good. The whole has done a good service, but do we want to have an arbitration which is sort of lex mercatoria, or we want to keep it in some way? I think this is a problem for Pro to discuss in the next shipping and the law. And then the last proposal for, I don't know, perhaps it may not be new, I'm not so adjourned. I think mediation could be something very good, but I think the best thing, I remember when I was the president of the Port Authority of Naples, I couldn't do arbitration, but sometimes the party said, you have to tell us, perhaps there were 2 terminal operators or a shipper, and they said, okay, but if you tell me that I have to say, you have to follow, because I have no power to force you, but be aware that, you know, then if you will not follow my suggestion, I will get very annoyed. They have been always following this suggestion. So unfortunately, not every mediator could be the president of the port. So what about if the mediator is already appointed as the arbitrator, sole arbitrator, or the third arbitrator of the arbitration, which will be pursued if the case is not settled in the mediation. This probably should, person like Jonathan, who did a lot of arbitration, now does a lot of mediation, but still do arbitration, would be very useful. But you could merge together perhaps people like Clive and Jonathan or audio mediators. I think if the parties went to the arbitrator, and the arbitrator would try to have them to settle their own cases, and they know that, so they start. It's a bit like when we try settlement before the court. No, you try to understand, well, and the judge say, why don't you settle this? It happens sometimes. In labor case disputes sometimes. And you try to understand. And so I think this would be a big pressure on the party to settle, because they say, okay, then if we are not reasonable in the mediation process and in the settlement negotiation, this man will be the arbitrator who will decide our case.
I think there are always problems. I mean, the point is raised, but I think there can be problems because in a mediation, one of the ideas is that the parties are talking without prejudice and perhaps being more open with the mediator. And so if the mediator knows things that one party has told him but has not been said to the other party, he's placed in a slightly awkward position as an arbitrator. But look, we said at the beginning we'd try and keep to time, and our concern when we started was would we have enough to say to fill the time? Well, because we're still paid by the hour, or the lawyers here are still paid by the hour, I'm sure we could go on, but we're not going to. So I would thank all of the panel for their participation and hope that what we've said has been of some interest to you. Thank you very much.
No, stay.